Hello, everybody, and welcome to what promises to be a really great and interesting and fun event. I want to welcome very warmly Commissioner Margrethe Vestager in 1 minute. And first, I want to say, on behalf of my law school and my dean, Trevor Morrison, Harry First, who is the co-director of the Competition Innovation and Information Program at NYU, we welcome you very warmly. We're very honored that you can be here today. So perhaps you know her biography already, because there is quite a lot of information that the press has published lately. But of course, I will say she is, of course, the relatively new European Competition Commissioner in charge of competition. And she was, just before that, the Deputy Prime Minister of Denmark, and also the Minister for Economic and Interior Affairs. The commissioner, at the age of 21, was appointed to the Central Board and Executive Committee of the Social Liberal Party of Denmark, and is now the leader of her party. In 2001, she was elected to the Danish Parliament and became chairwoman of the parliamentary group in 2007. In November, when Mr. Juncker became the president of the European Competition Commission, I noted with great interest his statement of his objectives for his commission and his charges to you. So we noted his agenda for jobs, growth, fairness, and democratic change. And then we noted, as he said to you, you will be the Commissioner for Competition. You will, in particular, contribute to jobs, growth, investment, competitiveness, and then at a later place also digital single market, energy policy. We know you are on task forces for those, and industrial policy. And he noted also that the Juncker Commission promises to be modern, efficient, transparent public administration with full independence and impartiality. And we know from the remarks that you have made publicly, at least that I have witnessed, that you strong deeply from your heart behind those values. We noted also in that connection when the president of the commission proposed your mandate and your integration with the other functions of the European Union, that you said, yes, competition will not be the lonely portfolio. So you've already launched the Juncker Commission competition agenda with great vigor. You have already galvanized the attention of the world. And of course, relatedly, your commission has filed the statement of objections against Google, which may be one of the subjects of discussion after your remarks today. Commissioner Vestager will give remarks for about 20 or 25 minutes, and then she has graciously agreed that she will answer questions and engage in discussion with us until the end time at 2 o'clock. And so I will give the podium to Commissioner Vestager, who will talk to you about enforcing competition rules in the global village. Thank you so much for being here.
Thank you very much, Eleanor. Actually, we agreed on first names, but I saw that slipped a little. But that will be very good because it makes me feel so much safer. I'm not a lawyer. If I wanted to be a lawyer, I should have made other choices years and years and years and years back. So I will by no means compete with any of you in being a lawyer or knowing by heart the legal substances. And that's, of course, a deliberate choice, because this is not my role to become a lawyer. Neither is it the role to overdo sort of the things of the chief economist team. It's my role to be the commissioner, to be the decision maker in place, and of course also thereby to enable the casework for the competition law enforcement. And to take a new position as I have done at a time where you have been thoroughly in the spell of a very, very critical situation, and we are building something new, of course, you wonder how will history book describe our times? And of course, or I think it's most likely, there'll be a chapter on the digital revolution. Of course, there will be chapters on terrorism, on 9/11, and of the financial crisis 2008. But I'm not, you don't know, basically. But one of the things that I think we do know is that the textbooks of the future for my grandchildren and their children will describe the process of globalization. What happened in those years when the economy became global, where news became global, where things changed. It can be seen from so many different viewpoints, of course. But today I will offer one view on globalization which may not hit the headlines ever, but which I consider very important. Because as just stated by Eleanor, I'm the responsible commissioner for enforcing EU competition law in Europe's internal market, and I've been doing that since last November. So I am only 6 years old in the trade. And the authority that I'm responsible for, Competition Department in the European Commission, has more or less the same antitrust agencies as the Department of Justice and the Federal Trade Commission here. So you'd find a lot of similarities. So today I would like to talk about the implications of the progressive integration of the world economies and how that integration influences the work of competition law enforcers. Competition is mainly about interdependence. Investment, trade, people, ideas move freely around, can engage in a completely different way. It has been increasing ever since the Second World War. And the numbers in itself, they are startling. Since 1950, the growth in real GDP on average was a little less than 4%. International trade volumes, they have on average grown by 6%. That little difference between 4 and 6 makes an enormous difference 60 years later. And as a result, today value chains are global, truly global. Companies increasingly operate internationally. If you start a company today, a lot of entrepreneurs don't think about having a national market. They think about how to become global. The biggest of the global entities, they are without any sort of particularly strong connection to any country or to any particular part of the world. They are true globalists. And in this landscape, countries and regions, thousands of kilometers apart from one another, has come to rely on wealth and social well-being on each other. As I see it, globalization is a fact of life. And you can't stop that. But what you can do is to manage it, to reap the benefits to the full, and to limit the negative impacts of globalization, which is obviously also to be found. Global markets brings benefits, but it also increases the need for a robust legal framework to ensure that markets stay competitive. And in that, we have been seriously challenged. Because at the same time as countries become more and more dependent, even though we don't share a common border, many countries have seen an increased need for robust competition enforcement at home. And the growing number of countries have felt the need to introduce laws, set up public and independent authorities to make sure that companies actually behave. In the past 25 years, and I think these are amazing statistics, competition regimes have increased from just 20 agencies in the beginning of the 90s to around 130 today. It's an amazing development. And I think it shows the ambition for law enforcers to keep up with the pace of globalization. The more established agencies has, of course, promoted and tried to engage in this development. For example, EU have fostered competition policy in countries of Central and Eastern Europe, and have used these who used to be centrally controlled economies. And this is a good thing, because it shows that a competition culture is growing all around the globe. However, then of course, new challenges arise, and we have to be aware of that. Just think about two multinational, or at least international companies who want to merge. Happens very often. Since a company will do its business in a number of different countries, they will seek approval with competition agencies in each of those countries. It's a lot of work, and I think a lot of companies experience it as a lot of red tape as well. It's not all, though, because when a merger threatens the competitive structure of a market, it usually gets approved on condition on certain assets and operations being sold, what we call a remedy package. What if different agencies accept different remedy packages? Or worse, if they accept inconsistent remedies? Then we have kind of a situation, and the business may find themselves, caught up in something very similar to what Kafka described. Because that's a real risk. If a national agency looks at things too narrowly, then we end up collectively achieving little more than keeping a lot of lawyers busy. And no offense, that's a good thing. But it may be too much. And therefore, of course, there is a shared responsibility actually to coordinate. It takes a lot of discussion, takes a lot of dialogue, takes a lot of cooperation for real, actually, to make this happen. And it's never going to be an easy ride. But one of the reasons why I'm optimistic is that this is not a process starting from scratch. It has been going on for a long time. As I experienced this just this week in Washington, the antitrust enforcers are already a global community. Last week in Washington at the American Bar Association, they had their antitrust spring meeting there. 3,000 people attended it. There were delegates from all over the world. I think 40 different enforcement agencies were represented. Of course, the majority of the participants were American, but I think a little less than a third, or at least a fourth, were coming with an international background. And what I saw and experienced firsthand was a common set of values when it comes to enforcement. no matter where they come from. And I think that is very, very fortunate, because enforcers make things happen in the everyday casework. So let me talk just a little about how the European Commission has tried to contribute to this and how I intend to reinforce it. But before I do so, just a little ride back in time, because when the founding fathers of the European community first made the treaties in 57, they had this bold vision of a true community. But they also saw that if we were to create a single market later on, well, then we also needed a common authority. And this is why the treaties allow the Commission to directly enforce competition rules against companies in our member states. It was for the Commission to ensure that state aids did not distort the internal market, or that cartels did not prevent it from reaching consumers. And we do not need to do this alone. Competition department that I lead work very, very closely with national agencies of the Union. We apply the same rules of the treaty, and these rules has become law of the land all over EU. And this cooperation has grown stronger and stronger and stronger over the years. We got harmonized merger control enforcement in '89. Since 2004, we have had the European Competition Network, which has proven quite efficient in getting the job done. Up till the end of 2013, the Commission investigated 122 cases. National authorities investigated 665. So we can talk of a genuine European system of competition law enforcement. And of course, I hope that these statistics also works as a deterrent, because at least part of what we do is to make sure that people know that we'll be there if somebody does not play by the rule book. Of course, we need to talk. We are in total 29 players, and of course, once in a while there'll be debates. But in general, I think that I can say that the system works. We have a quite consistent enforcement across the territory of the Union. As an institution with its own practice is predicated on the need of transnational cooperation, of course, it's no surprise that we also do this in an international way. There we do not have a joint legal framework as we do within the European Union. There are plenty of options though, such as, for instance, bilateral agreements. Some bilateral agreements are devoted totally to competition, such as the ones that we have signed with agencies in Switzerland, Japan, Korea, Canada, and the US. As a matter of fact, the competition cooperation agreement that we signed with the US in '91 was the first in this series. In other cases, competition provisions are included in a broader treatment, in a broader context. That would be free trade agreement, that would be partnerships and cooperation agreement, what have we. And this, of course, enables us to have formal agreement with over 30 different jurisdictions all over the world, and we have more in the pipeline. Another way to do this is, of course, to take part in international forums. We have been member of International Competition Network, which is the main forum for the 132 members. And we have been doing this for a number of years. We put a lot of effort into it. We put resources into it. All this work is concrete. Part of it is new, and we will organize also workshops and do the best we can to promote any practicalities. But no matter the international cooperation, no matter the papers that we write, no matter the meetings that we travel to, of course, the real cooperation is in the casework. When people feel that they can pick up the phone and call colleagues in another jurisdiction when they have a murder case. Because then cooperation becomes real. Then it's not just paper, not just an abstraction, not just something that some politician would like to see. Then it's for real. And I would like to give you some examples. In 2012 and 2013, we cooperated with non-EU agency in more than 60% of our enforcement decisions. More than 60%. And that is a rising trend. In 2010, 2011, half of our complex merger cases were reviewed with non-EU agencies. Half. In the following 2 years, this has grown, so now it's almost 60%. So it becomes a more and more international approach by need, of course, because we see it due to globalization. And the thing is, of course, that when people can pick up the phone, when they do a complex murder case, they build trust because they know and they sense and they feel the same values, the same way of looking at facts, and this is, I think, very important. We are also shifting from mainly a bilateral cooperation to multilateral cooperation. And it's all due to my starting point that value chains are global, that more and more companies will be present in more and more countries. Last year, 2 giant cement manufacturers, Holcim and Lafarge, informed us that they intended to merge. And this was truly a deal with global implications. The company that would emerge from this merger would do business in more than 90 countries. It's a huge company. During our review of the merger, we had contact with agencies from 8 different jurisdictions, those of the US, Canada, India, Brazil, Serbia, Mauritius, Kenya, and China. And eventually it was approved with a substantial remedy package. This, of course, is no time for being complacent because there is still a lot of work to be done. Globalization is still moving forward. It's still very fast moving. First of all, I think it is very important to keep promoting, to keep up the advocacy for our basic values. Procedural fairness, impartiality, transparency. Because even though it may seem as the basics, it has to be promoted all the time. And we should never forget the basic aim of, or the goals, which is, of course, to make sure that all of those companies, thousands and thousands and thousands and thousands of companies, who just do the right thing, who competes on the merit, that they can stay assured that we'll be there to make sure that those who do not play by the book will have to face the consequences of not doing so. And I think that is a very important message to come out with. You've probably been in a number of discussions, I think some of them are due to the crisis, where people say that, well, maybe this competition is a good thing, but it's a little inconvenient. And maybe it's Tuesday and it's not a good day to be competitive. Could we wait till next week, please? There is, of course, once in a while, the ghost of protectionism comes up again to show its head. And I think it's very important to take this debate head on. with the very basic message that if you want to be competitive abroad, you have to be competitive at home. If that not be the case, if you're cushioned, if you're warmed, if you feel secure, not by competing on the merits, but because you're being protected, then you will have a very, very hard time when you face the global market. And that kind of advocacy, I think, is very, very important. If any agency sort of shifts, do not abide by basic principles, it's not only a losing economic strategy, it will also poison the well of antitrust cooperation. And this, I think, is part of the case, and while we live in a global village, we also need to have global enforcement. One of the reasons why I very much enjoy being here is that this is just another chance to become wiser, because even though I find as a newcomer that my services are doing a very, very good job, of course we can always learn, we can always be better at what we do. So we will keep on sharing with sister agencies on the international scene. And hopefully, if you invite me in 4 years' time from now, and I have to, you know, count and evaluate what I've been doing, that you have been able to rely on me to make sure that we're impartial, we're rigorous, we rely on facts, but we will be there for those who do not play by the book. Thank you.
So, thank you very much, Commissioner Vestager. We really appreciate all of your remarks going through the global village, the need for cooperation, the need for competition advocacy. I would like to launch the discussion by asking this question. You, of course, have had a lot of prominence even since, a lot before, but even since last Wednesday when you announced the Commission Statement of Objections against Google. You've talked a lot today about the importance of convergence, the need for the world to be on the same page with a level playing field. Yet your example that you have set beginning on Wednesday, falls into that area of divergence under abuse of dominance. So what I want to ask is there a tension between the bringing of the Google case and the effort to achieve convergence and harmonization of law? Thank you.
Well, that is a very good and obvious question, I think, considering what I just said. But one of the things that I respect a lot is, of course, the fact that even though we share the same values, there are differences in our legislation, in our organization, and of course there will be differences also in the concrete market situation. And I think it is very important for law enforcers to be able to stand up for what they do in the concrete markets. And what we do is, of course, that we investigate what happens in the European market, and I have a lot of respect for my US counterparts that they do their job as well. So sometimes a diversion is also an illustration of the fact that there are differences to be respected, even though we try to converge as much as possible.
Thank you very much. Harry, do you have a question you would like to pose?
Google, should we, well, Eleanor asked my question, but I'd sort of like to continue a little on the Google question in a way. One thing that struck me about Eleanor's introduction is that your background is a lot different from, say, Bill Baer at the Justice Department. So the people we tend to nominate to run our competition agencies are, you know, antitrust lawyers. But your background is political. And I wonder, and particularly in light of a case like Google, which has dimensions that are not just straight, you know, competition law, but raise other political issues. I wonder if you've had a chance to catch your breath and think about what sort of comparative advantage that might bring to you in terms of the political dimension of competition law enforcement. You know, I brought this with me, Microsoft Cache seen as factor in Google case. This was the New York Times on Thursday. I had to mention Microsoft because that's what I do, but as some people in the room know.
Buy his book later.
But yeah, buy my book later. But the political dimension of the, you know, the interest groups that are vying for the attention and hopefully, from their point of view, the right outcome from an antitrust enforcer. I wonder whether, given your political background, you know, sort of how you see it, and whether you think that that the political dimension actually might be helpful in what you do and your political sort of skills. So.
Well, first of all, not to be, I guess you know the British character Miss Marple. And not to be too much like her, but there are only so many variations of a human behavior. And I feel that a lot of the things that I have seen in my political work, I also find in European politics and some in global politics. And you know, it takes one to know one. So that enables me sort of to get through to the real thing. And on a more personal note, I have been working as a legislator in different roles in more than 20 years. And one of the things I've come to realize more and more and more is how little legislators enforce implementation of what they do. And I know, and unfortunately that's my own personal experience, that if you do not put as much political leadership into implementation of new legislation, it will not be implemented the way it was meant to be. And then legislators come back 2 years later and they're disappointed that it didn't get the job done, and then they put on top of it new regulation, and then everyone else gets frustrated because then you have layers of legislation never being fully implemented. So for me, it's a very welcome opportunity to enforce regulation and legislation already in place. And therefore, I put a lot of emphasis on that. And the second point is that one of the reasons why I have been, you know, actively promoting the European Union since my first political breath is the fact that it's based on the rule of law. And that everyone therefore has their say. So in that respect, I find that it's relatively easy to recognize where does politics come into the picture, and therefore also how to fend it off. Because I think that is very important. Because if in our casework other businesses would see politics sneaking in, I think it would delegitimize our operation. I don't spend much time in courtrooms, but from my understanding, judges pay very little attention to emotions and opinions, and a lot of attention to facts and evidence and the interpretation of facts. And I think that's important.
Thank you.
We would like to invite questions, Mr. Harkrider. Oh, I should give you this. I thought there was going to be a mic on the floor, so come.
Hi. So thank you very much for coming to speak with us. It's very, very interesting and enlightening and gracious for you to do so. My name is John Harkrider.
Even though I just said it, but for the record, thank you.
Hi. So this is my question. My question is that sometimes when you're doing analytical work and you're trying to do public policy, which I think is what we're all, in many respects, trying to do in antitrust, there are many theories out there and many questions as to intent and what a company was actually trying to do. But one of the observable things are facts on the ground. And so you're able at times to have what I would call testable propositions or disprovable propositions. And you can say, okay, what should we expect to see as a result of somebody's behavior? And I think what's striking when you look at sort of the allegations, and this is a question about Google, when you look at sort of the allegations about Google's conduct, should you expect to see some impact from that conduct? So when you look at, for example, Microsoft's behavior with respect to Internet Explorer and the bundling that it did and the antitrust case that was brought, you saw Netscape's share, drop from 90% to 10% and a commensurate increase in Internet Explorer's share. Maybe nothing happened with respect to Microsoft's share in its operating system, but you saw this very dramatic shift on the browser shares. But when you look on shopping and you see sort of the growth of Amazon and eBay, and then when you look on mobile apps and you look at the growth of whether it's Facebook or Twitter, and since you started speaking, I actually downloaded 2 competing Google products on a Google phone. So I downloaded, a competing map application. I downloaded Bing, and when I clicked on, not only on Bing, but just tried to run a search, it said, Bing is now your default engine. So it completely overran what was in Android. So I know that's very long-winded, but the question is this. What effects should you see if Google's action is something that harms competition and even competitors? Shouldn't you see a lack of growth in shopping? Shouldn't you see Google's share in shopping increase beyond single digits? Shouldn't you see a lack of growth in competing mobile apps? Or should you expect to see nothing and just go based upon a perception of a company's intent?
I think that sometimes you have to also keep things simple, because it's obvious that the digital world changes very fast. Some uses apps to find a way not to be found by general search and to try to keep consumers loyal within the world of the app. New things happen with new platforms coming up, like Amazon or eBay or Etsy or whatever. But all that being told, in the European context, when you see a dominance of general search of more than 90%, which is a de facto monopoly, consumers have to a large degree chosen the Google products, probably because they like it. At least that's the situation in my home. Then of course, when people complain about the behavior of someone having a dominance in a certain market, a complaint saying that we see that this dominance is used to promote services in a neighboring market systematically and not by the merits. Then of course we investigate to see, is there any bearing to these complaints? And that is what we have ruled out in our preliminary view in the statement of objection, that this is the case as we see it right now. And then you can have different discussions about what effect should be seen. One thing I think you can be certain of is that those who have complained, they have experienced effects. And what, of course, we fear is that if systematically by Google General Search you're being shown the Google Shopping comparison site, that may discourage rivals to be as innovative, to invest in those areas, because that they fear that they will never be found. And that, of course, is a much more simple approach, you can say, but that's what we have stated in the statement of objection.
Steve Halk, and again, say your name.
Yeah, so my first name is Steve, and for the record, the last name is Halk. And I hope you won't mind if I preface my question with a compliment to you. You've been described in the papers here as a steely foe of Google in Europe, and the Iron Lady, but you're very charming. So we do appreciate your being here. And I have a similar question. As you know, in the United States, one of the things that enforcement agencies look at is consumer harm. And so my question is, have you gotten complaints from consumers in Europe about Google, and can you describe the quantity and the nature of the complaints? And what do you think is the consumer harm here? Have Google's practices made it more difficult for consumers to find the products they want? Have Google's practices raised the prices consumers have paid for the products that they're buying? And if not, how do you describe the harm to consumers in Europe from the practices you've challenged?
Well, first of all, thank you very much for the compliment. I guess that most media would like a conflict, and that's what they're building up to. But it allows me to say that I have no grudge against Google. We have made a statement of objection, lining out our preliminary view concerning a certain conduct. And that, to me, is very important, because I wish for every company to flourish and to be successful. But when we have a case, it's usually a case about a certain conduct. And this, in the way that we see it, is a pretty straightforward abuse of dominant position. And therefore, what we fear is, of course, that it is hampering innovation and investment. And therefore, of course, at a certain stage, also harming consumers. But I don't think that it is the time to find, a very narrow definition, because in the European context, we're talking about a company which has a very dominant position in one market, and what we outline as our preliminary view in the statement of objection is that this has led to a favorable treatment of its own services in a neighboring market. And that in itself is enough to carry a statement of objection and a preliminary view.
Thank you. Rachel Brandenburger.
Thank you. Rachel Brandenberger. I'm a senior advisor to Hogan Lovells here in New York, and I'm a former Special Advisor International to the US Department of Justice's Antitrust Division. Sorry, that's a terrible mouthful together with my long name. Commissioner, thank you so much for coming to this rainy New York today. I wanted to pick up on your comment about the globalization of business and commerce, and I think the implication that you also made of the continued growth of competition law regimes and competition agencies around the world, and ask you, my question is not related to Google, ask you more generally how you see the way to reconcile businesses' wish for harmonization around the world with this continued growth of agencies and competition law around the world, and perhaps specifically whether you have any particular goal or measure of success for the European Commission in this regard during the term of your commissionership.
Well, first of all, I think New York has been more or less as welcoming as it can be, because I came here by train Saturday afternoon, and it was warm. It was so nice. And then we got a full Sunday where it was cool, but the sun was out the full day. And now today, every tree, every plant is being watered. And I think they may need it. It is truly a pleasure to be here. One of the things about also the globalization of competition law enforcement is, of course, to get it started. Because with the growth from 20 to 130 agencies over just a little more than 20 years, of course you'll see some divergence, because some are new, some are relying on very new legislation, only being passed a few years ago, so it takes some time to get practice and experience. And in that, both my services but also myself engage in outreach to share knowledge, to help out where we can, because it took European Union like 50 years or so to get to where we are today. Here in the US, you've worked on this for 100 years, I think, something like that. It's very sophisticated. So we, of course, should help where jurisdictions has been established within the last 2 years, 10 years, 20 years, but also respect that it takes some time to have 100 years of experience. I don't think that we will be able to make sort of very specific goals, but I do hope that the work that we do will get the feedback from global business that they see that there is a convergence and that they are not being burdened by even more red tape or even more conflicting views from antitrust enforcers. Because this is of course truly burdensome for companies if we as enforcers place them in the very, very inconvenient situation of, for instance, inconsistent remedy packages. That must be a sort of kind of a stressful situation for a couple of CEOs trying just to do their job. So hopefully I build on the willingness to this cooperation, and I also personally engage in it.
Thank you. I just want to add, because Rachel Brandenberger has been really instrumental when she was the advisor in our Justice Department to making consistent remedy packages and was really out front trying to do that. So there were several hands up. All right, may I, you go first, and Scott Hempel and you, and because we're running out of time soon, so I want to see other hands that back here, and is it? Oh, Junro. Okay, so can we start with you, and we'll try to get the rest of you. We have about 10 minutes.
Yes, I'll be very brief. Thanks, Commissioner. I'm a reporter for the Wall Street Journal, by the way. I'm not searching for conflict here, I promise. We reported earlier today that you guys were going to file a statement of objections against Gazprom. And I was wondering if briefly you could tell us what your biggest concerns are about Gazprom's practices.
No.
Thank you.
Thank you. Scott Hempel.
Hi, I'm Scott Hempel. I wanted to, I guess this is coming back to Google at least a little bit. So I could imagine innovative companies in the US and perhaps elsewhere taking a look at the preliminary statement and asking, okay, what does this mean? This is a question about product design. What does it mean for product design for us? If I have a popular phone and I want to add a watch, but the watch only works with my phone, or I have a social network and I want to include photographs, so I buy a company like Instagram. I'm not meaning you to opine on specific examples, but I guess what I'm asking is, I mean, at heart, part of this case is a question about product design. It's not just 10 blue links anymore. Everybody agrees we're going to add all kinds of other things and intersperse them, right? And I take the point about treating your own content differently from other companies, but I'm just wondering what, if any, comfort you feel like the Commission could give, or guidance, or help, or just to help me think about how to explain to students when I teach my antitrust class, which kinds of innovations are going to be permitted, and how do we know whether something's going to stray too much into the lanes of other companies? Because there's always going to be somebody else, I would think, or very often there's going to be somebody else that's already making the thing that's now part of the new and improved product. Just wondering if there's any help you could give and how to provide that sort of comfort.
First of all, in the statement of objection, we do not line out what exactly should be expected as a possible commitment or solution. But one of the things that we've been working with is to try to find another solution than, for instance, screen design or algorithm control. Because if I was able to do that, I shouldn't be here. I should be I don't know what billionaire having my own company. I think it is very difficult to make commitments which is based on either the screen design or the algorithm, because in both cases you would hamper sort of sources to innovation. Because there is, as you just mentioned, we come from a past of 10 blue links, and now we have a completely different screen design, and I think everyone enjoys that. When it comes to the algorithm, there will of course be completely legitimate concerns as for the company to change its algorithm, because there will be other companies who will be challenging that algorithm all the time and trying to beat it. Which is why we have said that, well, we're looking for something which is more based on a principle and therefore much more future-proof. Without going into much detail of that, because basically in the end it's going to be put into real life by real people in real companies. But for me that is very important, because otherwise we would, could have this meeting over and over and over again, and therefore future-proofing is very important, and principles. For instance, one could be to consider, how can we make sure that even if you have a very dominant position, you do not use that to favorable treatment for some, but to treat things evenly, just the same.
Thank you. Now, of those that I've already called on, let's go down that list. Yes, you are next.
Sorry. Thanks for speaking today, Commissioner. President Obama made a statement to the tech blog Recode about suggesting basically that this was sort of European protectionism, and I wonder if you could comment in your statement last week, or earlier this week rather, you talked about the role of U.S. companies in the investigation. I wonder if you could talk about how important U.S. companies' role was in the Google investigation. Thank you.
Well, first of all, I think it would be plain stupid to make it a point about what flag, because we need business in Europe. We need investment in Europe. We need any vibrant, competitive company to be in Europe. It's a beautiful place to do business. And therefore, basically, the flag is not important. And I think about 1/4 of the complainants in the Google case are US-based companies. US-based companies also play a large role in some of the business associations that have been complaining. So basically, we see a relatively balanced picture. With the concerns that some have, of course, I will also ask my services to look back at some of the statistics when it comes to cartels or other decisions, and I truly can find no bias. And I think that's very important. And I hope that also sends a message to businesses with American or Asian or whatever background, that when doing business in Europe, we will do our best to find out if Rivals is not competing on the merits.
I'm Ying Wu. I come from China. I'm the student at NYU here. So my question is related to China, which has so many state-owned enterprises, and these enterprises are now becoming more active in engaging in global market. So do you think that is there any difference in situations when these state-owned enterprises are engaged in terms of the enforcement of the competition policy, especially in light of the political motivation of these entities, and also there are many advantages and benefits or privileges that are received by these state-owned enterprises from their home country?
Well,
Yes,
I think it is very early to judge upon that, because it's still a relatively new thing that we see a lot of Chinese-based foreign investment in Europe. But it is coming in more and more, and I think anyone should welcome this situation, because these are also very vibrant, important, and innovative companies. So they should, of course, be welcome to do business in Europe. I don't know now if it makes a difference if you're a state-owned company or privately owned company. The one difference that won't be there is, of course, that you have to abide to your EU competition rules if you are active in the European market, no matter the ownership.
Thank you. So I know there are two here, one in the back and then Junru. And for each of you, it has to be short.
Yep. Thank you, Commissioner, for being here. My name is Daniel Garcia. I'm an LLM student from Mexico. My question is related to the idea of global enforcement in a global village. The ECJ gave a recommendation a few years ago saying that European courts should not enforce arbitral awards which contravene Article 101 of the Treaty for the Functioning of the European Union. These guidelines were severely criticized for favoring the interpretation of the European Union Treaty over the New York Convention for the recognition and enforcement of foreign arbitral awards. In this regard, taking into consideration jurisprudence worldwide about public policy has regarded the concept as being related to the most basic concepts of justice and morale. Do you consider competition law to be related to such, especially because there's been postures by countries saying that the way in which European countries structure their markets do not necessarily have to do with justice or morale in global times? Thanks.
I don't think I know enough to give a proper answer to your question. So maybe I can come back, maybe we'll meet in different positions in a couple of years from now. But for me, it's not so much a question of morality or ethics, but something quite related to it, because competition is also a very concrete way of showing that we are all created free and equal, that no one has can be a noble in the marketplace. You should compete on the merits. If you have something to offer, you're welcome. This is the rule book. Apply it, no matter who you are. So in that respect, I think that competition law enforcement, even though it sometimes seems abstract, technical, difficult, something for lawyers and economists taking place in non-transparent places, I still think that it's a very concrete way of showing very basic values about people being equal and all deserving mutual respect.
Thank you. Will you take one more question?
Yes.
It is 2 o'clock. Gender.
Hi, thank you, Commissioner. I'm Junru Liu. I'm LLM student here. My question is related to the point that you mentioned about the international cooperation. My question is how to cooperate when different jurisdictions promote different competition goals. For example, in United States, the competition purpose, the goals of competition law is to promote consumer welfare, but in European Union, the underlying rationale for competition policy is promoting internal market. While in South Africa and China, you have like public interest or even national economy to be promoted through competition policy. I was wondering how could you like cooperate or cooperate in this circumstance to reconcile different value choice instead of applying like the same pattern economic analysis to different market conditions. Thank you.
Well, I think it's maybe it's a thin line or maybe it's kind of deep, because I think you're addressing a number of layers here, which is very important. One thing is the concrete casework, where you would apply your case law, you would apply economic analysis, you do both to try to get a grasp of the situation. Then, and I find that this unites jurisdictions in a number of different parts of the world, is that what we are trying to achieve is competition. Not competitors, not something else, but competition in itself. And then underneath that, we may have different wording, so different ways of expressing it. But I think that if you do a roundtable with enforcers around the world, you'd find that underneath the wish to promote competition and to go for or against anti-competitive behavior, you'd find that it's because that people actually value equal opportunity, that by the end it's the best for citizens to live in a competitive environment, because it not only creates wealth and prosperity, it also creates jobs, and by that enabling the individual to pursue his or her dreams. And we may express ourselves in different ways, we may have different legislative framework, but I think that if you boil it all down, you'd still find that by the end of that process, there is a human being who wants to reach out for the dreams of his or her life.
Thank you very much. Now, we are going to close in 1 minute. This was terrific. Your questions have been fantastic. We wish we had about 2 more hours to discuss all of them. Harry's going to say a word, I'm going to say a word, and then just thank you.
Well, you have such good questions. You should all take our courses. I just want to comment on what you said at the end, because I think what you said at the end answered my question at the beginning. So I said, you're not like Bill Baer. You have a political background. I love Bill Baer, but I mean, you have different background. And at the end, I think it came out, and I jotted down a few things. Antitrust, competition policy, is not abstract and technical. Right? At the heart, it has certain very important values. And it's, I hate to say refreshing, but it's good to hear those articulated. Right? Equality of opportunity, competition on the merits. So these are not always easy to translate into specific cases and decisions. We'll have arguments about Google, competition over policy on Google, perhaps. But emphasizing that aspect of competition policy, I think, is really important. And from my point of view, I think in part it speaks from your background. So I'm glad to hear it. I'll just say before I turn the mic over, and Eleanor can thank you all, I'll thank you all for coming on behalf of programs sponsored by our Competition, Innovation, and Information Law program here at NYU. So, but we accept your invitation to come back. Thank you so much.
Thank you so much. Yes, at heart, we all want competition, and we want competition for empowerment and markets to work and people to get what they want. And if I'm really trying to repeat and summarize, look at the facts first, apply our standards and formula, and in the end, we're not, with all the divergences, and even with all of the public interest divergences, we will be apart sometimes, but we're not that far apart. Margareta, thank you so much. This was really wonderful. Again, to the audience, thanks for those great questions, and we invite you back often and always. Thank you.
Thank you.
Bye-bye.